china, the Navajo pots, even the pillow that says, "My family tree is full of nuts." But hadn't Jesus clearly taught that all our treasures should be heavenly? I know people whose lives are centered on what they own. Cars, clothes, houses. Was I becoming one of them? I run my hand over the faded cover of great-great-grandfather's Bible. As suddenly as the oppressive fear descended, it lifts. Yes, I love my possessions, but I love them because of the memories they bring to mind. Memories of dear people, some still living, others gone on to glory, who were loved and treasured parts of my life. Lord, thank you for the precious memories forever alive in my heart.
You too. Thank you so much. We appreciate that. I'm really grateful for Ben Selters for being here today and doing our program on living wills and trusts. Ben has been a part of Pilgrim Church for years. His family raised his family here, and he has also been our controller, and he also is on the board of trustees, which he has been on the board of trustees for quite a few years now too. But I really appreciate being here because I know a lot of us are in the process of either doing wills and trusts or updating, and we all have a lot of different questions. So I really appreciate Ben coming up here and talking to us about our wills and trusts. Thank you.
Okay, I might start off a little bit too simple for everybody, but it's hard to know exactly where the audience is on everything. So a living trust is one way to have property prearranged for passing on when a person is no longer able to manage it, so someone else can step in and manage it for you, or if you passed on, then for somebody else. There are other ways to do that. You can have co-ownership and put people on with authority and ownership at the present time. But a trust is a little more comprehensive because it can allow that transition to happen in a fashion that you want and who you want it to pass to. And if that person can't, then maybe an alternate, and give them rather complex arrangements of what they're supposed to do. It's probably easier for all of you to get the information you want if you ask questions, so why don't we assume that you can interrupt me as we're going forward if something's unclear or it leads to a particular question that we should explore a little bit more. Living trust is a fictitious item. It's a document that creates something that's separate from you. You're in charge of that. You can make changes, sign whatever you want it to sign, but it goes on after you as somewhat similar to a corporation to be in charge of whatever property is in the trust. So it's a plan of who and what they're supposed to do, and property that's connected to the trust, because it's not automatically everything you have. We need to specifically put property in a trust. So you could have a trust that you fund with a little bit of money for a grandson, and that would be a trust. Living trust, typically it's going to be your main investment assets that are in the trust with your plan of what happens if you became incapacitated or passed away. Critical element of that, of course, is who's going to be in charge at a point when you're not going to be in charge anymore. And so that can be who you pick, one person, more than one person. Sometimes that's contentious that not everybody in the family agrees who's the right one to be in charge. More than one sometimes can work good with it. Teamwork, if it was a second marriage, let's have somebody from both sides of the aisle. But it's also a situation that has more friction sometimes, so it's something that needs quite a bit of attention. That trustee is not required to make reports to the court. They're basically off and running to make transactions, so you're giving them a substantial amount of authority once they step in after you're no longer the trustee. So we want honesty and intelligence and maturity, and once in a while, that doesn't always happen, so it's a reason to think through that pretty carefully. Who's the trustee? They're supposed to follow what's written there, but once in a while, things don't happen always like they're supposed to. The second key element, of course, is the plan for distribution. So instead of just having a co-ownership, a bank account with your name and the children's names on it, you can specify within the trust how that distribution should be. Equal, not equal. What if someone is incapacitated, disabled, or too young to manage? Then maybe this trust is going to keep going because the plan isn't ready to distribute property and be over with. So someone's going to continue, not as a guardian, but continuing as the trustee with authority and power over the property to help somebody else with payments that they would have discretion to deal with. There's a variety of issues that can, of course, come into the picture. One is if there's individuals that are on Medi-Cal, so we have kind of a lower income situation. However, Medi-Cal is much more of a middle class problem with a huge expense for skilled nursing care. And so there's the issue. I can't go into too much depth on that right now, but skilled nursing care expenses can take quite a bit of money year after year. So if someone qualifies for Medi-Cal, they can still keep their home. They intend to return to the home. That doesn't disqualify them. The amount of cash that they can, investment they can have besides that has increased over time. When property is in a trust, the current rule, which doesn't make a lot of logical sense, is that there's no recovery, there's no repayment out of the family home when it's sold if it's in a trust. If it has to go to court, because there's no trust, it's just subject to a will, Medi-Cal is still in a position where they can request a reimbursement for all of the past expenditures they've done for your medical benefit. Property tax is a rather significant issue these days. As you may know, if you've had your home for quite a while, your property tax hasn't changed too radically over time. If you talk to the neighbor that just moved across the street from you, their property tax could be 5 times higher than yours, more than that, just tremendously different. And the issue used to be, or still is, about whether other people can take that property tax amount or they have to start over again as if they were buying the property, inheriting a home, real estate that you have. So Prop 19 was voted by the voters in 2020. Not sure everybody understood exactly what it did, but it reduced the parent-child transfer exclusion. So before then, parents to children couldn't pass unlimited amounts of property, but it was a fairly high allowance where they would keep the same parent-child exclusion for the same property tax bill the parents had. Now, parent-child exclusion only applies if the children move into the residence that was the parents within a year. But any other property, if they don't move into that home or any other non-residential property, has reassessment. So that's quite a significant picture to keep in mind as far as what's going to make sense for the family going forward.
Can that extend to grandchildren instead of child caregiver generation?
The grandchild exclusion does exist, but it's very limited, meaning that the children of the parents of the grandchildren have to be deceased, have to be orphans.
Okay.
So if the children are living, then passing to the grandchildren doesn't apply.
Is it more for like a daughter or a son or from the family members? I mean, because I did the same thing with my son when I sold him, but or he was able to keep it, the property at the
Right, if it was your residence and passes to a child, it doesn't have to be a death. So that parent-child exclusion can work. It can work backwards. You can move into your child's house if it was their residence and now it's your residence. There is a certain dollar cap on that, so it's not quite unlimited. Besides the residence, other assets are something to keep in mind. If there's a securities account or a significant bank account, that could also be connected with the trust. It's important to have the ownership, have those statements coming to you that says it's in the Jane and Jack Smith Trust. That's the key part, is being sure the titling is to the trust. If it's not, it's not quite the end of the world. Very typically there's a will, a pour-over will that's part of this package, so to speak, and the will says anything else we forgot about or we acquired later goes also into the trust, but sometimes that has to go to court to get it put into effect. So we want to focus on being sure that the assets are titled the way we want to, so we don't have any issues there. If I could get away from trust just a little bit, again, if we're looking at kind of having an arrangement where your affairs are in the best order they could be, then it's something to also consider a power of attorney. So that would be a document that typically would step in if you became disabled. For people that are still living but disabled, they can't sign the pink slip for the car that's sitting in the driveway and not being run anymore. No one else can sign while you're living for that. The power of attorney is going to help on that. It's going to help if you call up and say, well, I don't need this cable package anymore. Well, I need to speak to the one that set up this contract. Well, they can't come to the phone right now. So, if we have this power of attorney, we can get that hopefully scanned to that company and they would respect that. But in certain cases, they like to play a little difficult on even simple business things. I think a key point for that is if somebody had an IRA or 401k, the worker is the only one that automatically has control on that account. So if there was an incapacity there, then who's going to deal with that? Arrange changes to the distributions and so forth. And that's why we want to have a power of attorney that gives us authority to somebody else so we don't get stuck on how we can access these different types of assets. For medical care, it's much more complicated than it used to be for authority. So an advance directive is the title of the document for California that's used to allow somebody else to speak to your doctor, give them instructions, support treatments or not treatments, change doctors, learn everything about you medically if you're not able to speak. As long as you can give them a thumbs up or thumbs down, then that authority is not going to supersede what you want. But you can understand that lots of times it's necessary for someone else to kind of come in and help manage that, but it's going to the doctor to just be sure they can hear what the right types of therapy and treatment are, or more serious life decisions. digital assets, what's on Facebook and your email accounts and so forth. I just mention that because you know the codes and the logins, but maybe nobody else does. And if that is important, you've got pictures, things there. You're Bitcoin investors. We need to have that knowledge in the hands of somebody else, so it just doesn't disappear. It doesn't happen too often, but recently I was helping a couple that lost their son, and they were just curious about emails that might show them a little bit more about his investments or assets, and we really weren't able to get very far because the contracts you have with these digital companies are very clear. It's just your business, and that's all. We want to respect your privacy, so they're going to adhere to that and not let other people necessarily get immediate access to that. So in some of these documents we say, yes, under the power of attorney or the trust, it's okay, these people can have access to that. I think probably the better way is to deal directly with these companies and get within their system and put down who your people are that can have access to that.
Ben, I know my sons went through when they lost their dad, as far as he did not have a will, he did not have a trust, and he didn't have any of these other things that we were talking about. So basically, my sons had to pay a lot of money to go into probate, because of the home he owned. And then he had a 401k that only had his name on it. And so this cost them money and a lot of time to do anything and still having to pay the bills. So it's like, it's really important that people, take charge and have a trust or will or a power of attorney or something that protects them, and protects their family, because that's what's hard. Your kids might end up being stuck with paying for everything,
So trusts are quite common, but if you don't have this information, education to know about the ability to get a trust, things can be left in your names. Very common for a married couple to have property as joint tenants. That passes very easily to the surviving people that are named as the joint tenants. But after that, then who does it go to? The title doesn't help us. And so that's probate is a court proceeding to decide what do we do with property that's in an individual's name that's passed away. So if there's no will, then there's the court proceeding to decide who's going to be in charge. It would pass to the heirs. Whether you're estranged from that group of people or not, it's still, that doesn't count. It just goes to who the heirs are according to California law. If there is a will, that helps you a little bit, but if there's only a will, it's going to help the judge know who's supposed to be in charge and who gets the property, but it's still going to go through a court proceeding for the will to be recognized and so forth. California is a little more difficult or procedurally complicated than some other states, but that's an issue. And a little further explanation, if we did not have real estate and we had a bank account that was in joint tenancy, husband and wife, they both pass away, we wouldn't have to go to probate court. If there's no real estate and that amount is not extremely large. And now that's, when I started, that amount that could pass with just signatures was $5,000. And now it's over $200,000 because it's worked fairly well to not have court proceedings when the amount is not too large and there's no real estate. We wait 40 days after death. The entitled people can all sign to share whatever that stock account or bank account is, some non-real estate investment. So not everybody needs a trust. If you rent an apartment and have a modest account, you can, and you don't have anybody else on that account as a pay-on-death person or a joint tenant, you can still avoid this court proceeding with the paperwork, basically. It's a small estate affidavit. Question?
Yes, I know she had mentioned 401k.
401k.
If you have a 401k and you have a beneficiary, does it go to probate or does it just automatically upon death?
Yeah, it would go to the beneficiary.
Okay.
So that's not going to be, it's just these assets that nobody else is named in any way. To pass on death, to be a joint owner, in trust for is sometimes how bank accounts are named, or POD, pay on death, savings bonds, POD, that's a beneficiary that can get that asset later. It's always good to double check if that IRA or 401k was done a long time ago, that there's still the right people that you want. Very typically, the forms are set up, you could name your primary, successor, spouse oftentimes, beyond that, then children, somebody. You can go beyond that, but you gotta get another piece of paper because the forms usually don't cover that. That's important.
So I work for the city Rialto. I have a 457 deferred comp, and then the city also contributes to a 401a. Can both of those get put into a trust, and would the name on the accounts be changed to the trust name, or?
So if it was a deferred compensation type account, so you haven't paid tax on that, like a 401k that schools and public entities have slightly different numbers that apply to the same thing, and we're still not changing the title on it. It's just going to be in your name, the employee's name that earned that benefit. And so the real question is, who is the pay on death beneficiary? And so that, how I was explaining before, that typically spouse, children, some version, you could say no, it's going to pay to my trust. So that would be a variation of that. There's no spouse. I don't want it to go directly to these children or grandchildren for education, so forth. So if the trust exists and we name the trust to receive it, that could work. Life insurance could be the same way. It's who you name expressly as the beneficiary of those accounts, or who's going to receive those types of benefits. When I was talking about the very simple estates, so we can collect the bank account for someone that just hasn't, is an apartment, doesn't have a high level of assets. The vehicle for DMV is very simple to change ownership. So the form is check the box on the heir. Where some things are so technical and complicated, I'm surprised it's a little bit on the other side. It's quite easy. It's a box, I'm the trustee of the trust, and there's a particular form for that. It's REG 5, but if you ask them, just say, I need to transfer the vehicle without probate, there's a form for that. Okay, I'm sure there's some more questions. So
I have another question, and it's just through experience with my family, my parents. I was put on their checking accounts and bank accounts, while they were fine and all that, just in case something happened, which helped me when something did happen. I was on that account so I could pay the bills and take care of things. So do you recommend that sort of thing? You would be, executor of trust, or I'm not sure how that works.
bank accounts have a variety of different arrangements that can be done. They are a little bit complicated. So if you were a power of attorney, if I was a power of attorney with my grandmother, then either one of us could sign on her death. Now I am the owner of that account. But if there was an understanding, well, she put me on that account just because I live close by and I'm supposed to share it with the rest of the family that's out of town, that creates kind of a problem because nothing's in writing. What was the plan? What was assumed on its face? It looks like it all comes to me. But a lot of witnesses might say, no. Of course you told me that you were just down there because you lived close by. So that's why it's a little challenging. But if you're down as a power of attorney on a bank account, that's different from joint tenants. So you just As long as the person is still living, you can use your power of attorney as a signer. The death, that authority stops, so that's keeps them from becoming the owner later on. But if we want that to pass on to someone else, that person, power of attorney is the wrong way to have it, because the bank, when they see your Social Security stopped, you can't touch that account.
That's interesting.
Pay on death, then you can't touch it right now, but when you walk in with a death certificate, now you're entitled to get it. So there's kind of sometimes a combination. I'd like to be able to sign it now. It should go on death to these people. So it's just a little more complicated, but it's certainly a good way that somebody's in place to be able to sign things. Because if I walk in with a 15-year-old power of attorney to the bank might not be sure that's something they still want to honor. So there's not necessarily an aging out of a power of attorney form, but if you understand from the bank's perspective, one person is on this account and all of a sudden a stranger is showing up with a paper and they want to take all the money out right now. So to have it set up ahead of time with the bank avoids any hiccups like that.
You're actually answering the questions they had. Okay. Going back to long-term care costs, if someone goes into a nursing home, skilled nursing facility, and they're on Medicaid, in the state of California, Medicaid, or is it still Medicaid?
Medicaid is kind of nationally in California. The same program is called Medi-Cal.
Medi-Cal.
Yes, same thing.
And then if you have your assets secured in a trust, is there still the 5-year look back for your eligibility? Or is there a time frame you have to have the trust? And then the second part of the question is it revocable or irrevocable, or does it not matter?
Yeah, so for Medi-Cal, I had commented about the recovery, that if you're already on Medi-Cal because your assets are low enough, you've qualified, even though you have a home, can Medi-Cal recover on your death? But now we're winding it back a little bit earlier, the initial application. Not everybody qualifies for public supported medical care, and so there's a disclosure of assets for that, whether you qualify or not. Again, residence is not disqualifying. There are certain things that are not. What we're talking about now is if we gave property away and enough time has passed, then you could still qualify, but that takes some advanced planning. So the look back is the government saying, well, if you gave it away 6 months ago, we're not going to help you then, and you did that too recently. So in the books, there's a 5-year look back. Again, it gets kind of complicated, but you've got to be giving it away. So if it's in a revocable trust, it's still yours. You have control, dominion over it. You can change that. So you haven't given it away for eligibility purposes if you have it in a trust that you set up 20 years ago. A trust, we're typically talking about revocable trusts or inter vivos trusts. That means the one that set it up has the power to change it, cancel it. They still own it, they pay tax on it. It's using their Social Security numbers for tax purposes. An irrevocable trust, something different. That's a completed gift. There's no more control over that trust. And so that would be something that you gave away. There'd be no inclusion of that for eligibility purposes if it was done far enough back. So that's partly an answer. Again, there are specialists and more tricks on these eligibility issues and so forth that get more and more complicated.
I have a trust, and both boys are equal beneficiaries. As you all know, my older son passed away. How does that affect his family?
So when you name beneficiaries, of course, that's just potential. When it's a revocable trust, we can still change that. So sometimes that would be an example of why drafters might say, well, you should look at this every few years, or if there are significant life events that happen and we need to update that. But if nothing has happened and lots of these trusts are tucked away and nobody thinks about it till later, then it's how is it worded really would be the key. So if nothing was otherwise done to be sure the language was appropriate for you, then we need to go to your document. Their situation is not in the picture. Well, your document, what does it say? It distributes to whom? And so if it was just A or B, A half and B half, then presumably that it's anti-lapse. It doesn't lapse. It would go on to their issue. I would usually always want it written within your document to my children. If one of them didn't survive, then to their issue. Or if you didn't like grandchildren, then only to the surviving child within your document. So that's clear. We're not just leaving it. But if it didn't say that, then it should probably go to their issue. You know, your document just names child's not living anymore. If that child had descendants, that child's will is not relevant.
Okay.
It's your document and how California law would come in and say, well, it's going to go to their issue. If it was your next door neighbor, the rule's not going to apply. It's not going to go to the next door neighbor's issue. It just stops. They're not going to get it.
Okay, so it is revocable. I updated it maybe 5 years ago. So it's time to update it again. How do you recommend I do that? Or what are my choices so that the issues, my grands, are now listed?
Well, an amendment, you know, we don't have to do a new trust. Typically,
Right.
these are amendments, and
Right.
so the amendment would say, for your trust that was originally done in whatever 2015, Article 6, which is the wording about distribution, is being removed, and now we're inserting in that place some other wording about distribution. So now the old trust document plus this new one needs to be together, so we have the complete one. So the questions I would think of course, is age. Are the grandchildren old enough to receive the property, or does someone need to continue the trust because they're underage?
Yes to both of those. One is of age and the others are not.
Okay, so, well, of age, then we think of 18-year-old as kind of being of age, but I'm not going to let someone get out of the room without saying, I think 18-year-olds are not always mature enough, even though legally, if they were down on the 401k plan, 18, they get the distribution. Unless we have the trust say, now distribution is going to happen on a schedule, maybe even staggered, a little bit at this age and maybe a little bit more at this age, and our trustee is going to be there to help them if they need it, however we want to write that, for education and healthcare only.
Who's in charge of that, setting that, who's in charge of the distribution?
So the trustee, so whoever is the successor trustee in the trust is going to be reading your document and following what it says. Right? And so if it says pay it out to everybody that's over 18, that's what they're supposed to do. Or if it says we can pay it out to everybody that's over 25, but if they're not 25, then I'm the trustee. I need to hold on to it and follow what you say, to invest it, keep it for them, help them for these types of situations.
So So I have to make a new second person to take over Bob's position, to be in charge of that money for the girls.
So you have a trustee right now. If you're not able to be the trustee, there's someone down for that trustee position.
Two,
Okay.
both boys.
Okay, and so if it was written that, if they both can't be trustees, again, hopefully that says that the survivor alone could be the successor trustee.
Ah, okay. I haven't read it, I need to pull it out and reread it, don't I?
Because if it said they're both co-trustees, they have to work together,
Yes.
work together, and only one of them is here to walk in and say, I'm in charge. No, you're not, because your wording says together. I'm giving you probably what it doesn't say,
Okay.
but just to show you how it's critical how the words are.
Okay,
Because the escrow for selling the house or the bank people are gonna read this,
oh yeah.
and whoever's named there and whatever formula is there, and we may have to go to court to clarify it if there's problems interpreting, or we didn't expect there to be a problem with this person being able to take over, so now somebody has to volunteer, and now the court's going to watch it because they're take the responsibility to be sure that person is probably bonded and everybody's okay with it. So again, we want to have backups so we avoid any questions that have to be sorted out by a judge.
So, obviously, one son, but the son that passed away, can I just have his wife take that position?
Okay, so presumably the surviving son can be the trustee by himself. Take care of things, follow your rules here in the document, and your rules might say that person should be overseeing his nieces and nephews, or when we come down to that, we've liquidated things, it's ready to distribute, the surviving son's going to receive his half, the other half now drops to your document that is named the mother of these children to be the trustee over their share. Not the uncle, the surviving son, but the mother. You would spell that out. That's not automatic. Because some...
Yeah, and she's only the mother of three of them. Now life does get complicated, doesn't it?
Some parents, in my experience, would say, well, I don't want my daughter-in-law to handle that. I'd rather have my other child that knows how hard I worked my whole life for this money and be sure that it gets hopefully directed in the right way.
Okay. So thank you. I have some reading to do and some thinking to do.
So, yeah, the wording is quite key on some of this.
I have another question. Say you have a trust and you want to update it, and so you make a few changes and different things. Now, since I have stock that is in trust name and properties that are in trust name and that sort of thing, do I have to send the new documents to my stockbroker? Because they have a record of, the trust. But I don't know if you make, update it. Do you need to provide that to them?
So, if you're doing an amendment, some people make lots of amendments because they change their mind about who's in their good graces and who all of a sudden offended them and it's no longer in. And later, no, that's... Sometimes they don't even come in to sign it. No, cancel that. Gets made up. I'm sorry, I'm off the track. So,
I appreciate it.
So, you wouldn't, because as long as it's in the trust, these other amendments don't really affect the fact that the stock account is in the trust.
Okay.
It's going to just stay in the same trust.
So you don't need to update anybody else. Okay, that's what I wasn't sure.
But there's always exceptions and odd things. So that story may not be quite that simple.
Oh, okay.
So now I see more often that when you go to the bank and set up, this is going to be in a trust account, okay, the name of the trust, okay, who's the current trustee, and your social security number, your address, and so on. Well, who's the successor trustee? and they're getting more of that information than they used to. So when the bank puts down who's that successor trustee in their records, then if you go ahead and change it and don't tell them, that arguably is going to create some trouble. I'm not happy that the banks do that, because I had to go to court one time because they said, no, this person's the next trustee. No, since that was the case, another amendment was signed with a new person down. And, it's hard to argue with City Hall or the bank sometimes if they make up their mind in South Carolina what's supposed to happen. So the plot thickens. But as far as assets, no. Distribution, they don't really care about that. They're not going to keep track of that, but they think should be the trustee, may be complicated.
Sounds good. Is there any other?
Wow.
So that's about what I was going to talk about then. Okay, well, thanks for your attention.
Thank you.
Yes, let's give him a big applause because we really appreciate it. And we are going to be serving lunch pretty soon, and Ben's welcome to join us also. And so basically, I'm not sure where Bonnie went.
She's in the kitchen.
She's in the kitchen. We are having soup, and I know there is no charge today. So,
But be sure to get your ticket.
oh yeah, we need to get tickets, and yeah, so we can, and hopefully everybody will stay for lunch, and they'll be in here shortly. Okay, thank you so much. We appreciate it.